All right, let's proceed. Good morning.
Good morning, Your Honor. Benjamin Keehn on behalf of Gregory Diatchenko. This case is before the court on reservation and report from the single justice of Mr. Diatchenko's petition for relief filed pursuant to General Laws, Chapter 211, Section 3, and Chapter 231A. The threshold question that is presented by this petition is whether the rule of Miller versus Alabama, in which the Supreme Court held a year ago, June, that the mandatory imposition of life without parole sentences is cruel and unusual punishment when applied to juvenile offenders. Whether that rule applies to persons such as Mr. Diatchenko, whose sentence is final, was final in the sense of Teague versus Lane before the June 2012 decision in Miller was handed down. I want to spend time talking about retroactivity, which of course, unless this court rules that it is retroactive, then Diatchenko and others in his position will die in prison pursuant to this mandatory life without parole sentence that the Supreme Court has said violates the Eighth Amendment. But before, I just want to touch briefly on the issues raised by the Suffolk District Attorney's Office. Contrary to the first argument that the DA makes, and I received the brief from the DA only a week ago, but the single justice did not in any way abuse her discretion or commit any error of law by determining that the issues presented by this petition are deserving of this court's full attention. And I can respond if the court has questions to these arguments by the Suffolk DA that 211.3 does not confer jurisdiction on this court for this pleading, or that an action for declaratory relief is outside the scope of CPCS's authority to assign counsel, and will do so in writing if the court wishes after this argument. But I want to speak further to why it is that applying the analysis that the Supreme Court has laid out for when rules are retroactive and when they are not, that the Miller rule clearly falls into the category of retroactive. The formulation for retroactivity that is most applicable, I would say, categorizes the Miller rule as substantive as opposed to procedural. And because it's substantive, it's retroactive. Because the rule of Miller alters the permissible punishment that is now available constitutionally for juveniles convicted of murder. And it does this in two ways. It first restricts the scope of 265.2 by effectively rendering unconstitutional the fourth sentence of that statute as applied to juveniles. That fourth sentence declares that anyone serving a sentence for first-degree murder is ineligible for parole. And at the same time that Miller restricts the permissible punishment in that fashion, it simultaneously expands the punishment options that must be available for children convicted of these most serious offenses by requiring that any sentence imposed be individualized, A, which is a significant change, and B, that individualized sentence take into consideration the so-called Miller factors, at least, the neurological and psychological realities that render juveniles as a class less morally blameworthy and more amenable to rehabilitation, such that an automatic imposition of life without parole is disproportionate. So before Miller, judges had no choice. After Miller, they do.
But they also, I mean, the district attorney and others argue that, yes, they have a choice, but one of those choices, of course, Miller suggests, is life without parole. So
I agree. There is a procedural component if one puts it in that term, but the fact that there is now a individualized sentencing hearing that is to be required no matter what sentence is imposed does not make it procedural within the Teague framework, because nonetheless the substantive law that exists, that may permissibly exist after Teague, is narrower and substantively different than it was before. Some of these cases are cited in the reply brief, but just within the last month, I think it is worth bringing the court's attention to the fact that the Supreme Court of Mississippi has ruled that Miller is to apply retroactively there, and it does so with language that addresses your question to the effect that our sentencing scheme may be applied to juveniles only after the applicable Miller characteristics have been considered by the sentencing authority, and as such, Miller modified our substantive law by narrowing its application for juveniles.
Now, your brief goes beyond retroactivity and speaks, I think, to what should happen upon remand. Is that correct?
Yes, I do want to address that important question of what the appropriate remedy is, assuming that this court concludes that it's retroactive. And I can turn to that, but I don't want to leave any questions unanswered about whether the law of Miller is to be applied retroactively in Massachusetts.
This court is not shy about asking questions, so why don't you turn to the issue of remand, and I'm sure if there are questions with regard to retroactivity, they'll be asked. But
well, before you get there, I would just like to, is your main point that it's, well, two questions, that it's substantive more than it's a watershed procedural issue, or is it both?
I argue that it fits into both categories. I think the most compelling argument is that it is substantive. There's that term of art in the Teague framework comes up first in Penry, is then taken up in a case called Bousley, B-O-U-S-L-E-Y, which talks about new rules that change the permissible punishment. As said by a number of courts that have addressed this, Miller is substantive because it alters the permissible punishment. It decrees a punishment impermissible, the punishment of mandatory life without parole, for a category of individuals, namely juveniles. So,
regardless of Teague, aren't we under our Danforth decision, permitted to say that we can choose to make it retroactive?
absolutely, and I argue that
So we don't necessarily need to use the Teague formula, do we?
not as a matter of federal law, you do not need to follow the Teague analysis. This court has in the past.
Well,
and so,
Sylvain suggests that we sometimes don't.
excuse me?
Sylvain may suggest, oh, sorry. Okay.
I know that this issue is before the court, and honestly, I think there are compelling reasons that Danforth makes clear why, regardless of how the Supreme Court might rule on this issue, this is a matter for this court to decide under Massachusetts law whether the cruel and unusual punishment of mandatory life without parole is to apply to some prisoners but not others, depending solely on the timing of when that sentence was imposed. But
Let's get to the relief issue, though. Your time is running short. This is not unimportant. What do we do if we accept your argument? Why isn't the district attorney's proposal the correct one?
the 265-2 cannot be saved because if one simply
So we eliminate the problem. It's not mandatory life without parole for your client. So he's parole eligible. Let us say we declare that.
That's unconstitutional in the petitioner's view because it similarly mandates an automatic punishment of life without consideration.
But it's not mandatory life without parole, which is what Miller was all about.
That's true. But the entire animating import of Miller, that the factors that reduce moral culpability and the capacity for change that call for some sentence other than the most extreme must be considered.
You mean the legislature could not mandate life in prison for this offense with parole eligibility? You can't do that?
If they enacted a statute post this, I think that would then, the question then becomes, is parole eligibility a meaningful opportunity for release? And we argue that it is not.
It's an opportunity for release. That's what it's all about.
It is not a meaningful opportunity for
Well,
release.
I mean, that's really not before us, is it?
It is before you. If
How can we assess the meaningfulness of, I mean, where's the record in this case? Where's the, it's not before us.
well, you can look to the appeals court's decision in Doe, which says there is no liberty interest under Massachusetts law in the future grant of parole. So if the remedy is go see the parole board, that remedy,
The remedy is you're eligible for release.
if that is the remedy, that remedy is unenforceable under current Massachusetts law.
So so the court has to impose a specific term of years less than life.
Correct.
It's a constitutional matter.
That is our argument, that is the only way to give meaning to Miller, a term of years sentence that provides the petitioner and others in his position with a meaningful opportunity for release, an enforceable, an appealable sentence, none of which is available if the remedy is that you see the parole board where you have no right to counsel, you have no liberty interest in ever seeing the street.
What about the amendments, 2012 amendments to, was it 279-24, saying that in life imprisonment sentences, the judge is to impose a minimum term between 15 and 25 years? Does that satisfy your requirements going forward?
Going forward, I would respectfully leave that question in detail to the next case, which I think raises it a little bit more directly. But I think there are significant ex post facto problems with saying that now, by operation of a decision here, parole eligibility will be increased to something beyond 15
All right, I
years.
was talking about prospective, but that's okay.
Well,
Could I just ask you a question about Miller, which I know you've, I think everybody has focused on saying that there's an aspect to it that's unconstitutional, but do you take it as completely dictum in the end when Justice Kagan says, because she sort of suggests that it should be tailored to, and there is a suggestion that tailored to means you have to have parole eligibility, but in the end she says, or a term that is less. That's one sentence in it. It's in the end, but it does, I think, inform the rest of the discussion. So it's not really, or it could at least arguably be read as not solely you can't impose on juveniles life without parole, but must consider the mitigating factor as a class that they're a juvenile, except in very extreme cases, potentially, but also that means a term of years. It's not, that's what she says. Nobody's mentioned
I
it.
do not disagree with any of that. I think that is a sensible reading, and it is in fact how some of them, in the petitioner's view, thoughtful decisions have approached this. I would commend to the court in particular 3 decisions that came out on August 16th from the Supreme Court of Iowa One holding it retroactive, that became the second state to do so, that's Ragland, and the other two decisions decided on the same day, very thoughtful opinions, Null and Pearson, applying Miller to term of year sentences, lengthy term of year sentences. Some would call them virtual life sentences. And the logic of Miller is that children are different. No matter what remedy is imposed, if the court does not embrace the principle that the punishment of juveniles convicted, even of heinous offenses, I would argue especially of heinous offenses, if those factors, if that sentencing proceeds as if they were not juveniles, whether it's a remote possibility of parole, whether it's a 120-year life sentence, whether it is, as the governor of Iowa did, in a, I would say, somewhat cynical response to Miller, of commuting all juvenile sentences to parole eligibility after 60 years, that will violate Miller too. So I understand that the question of remedy is complicated as applied to Mr. Diatchenko, who has demonstrated prima facie that, in the words of Miller, he is not incorrigible. He has changed. Like almost all children, he is not the person that he was. He deserves a second chance, and that second chance has to come from resentencing. I see that my time is up, and unless there's any questions, I would rest on my brief.
Thank you.
Morning, may it please the court. John Zanini for the district attorney, Daniel Conley from Suffolk County. The Attorney General's office is reserving 2 minutes of the argument for the Department of Corrections and the Parole Board, as we're on the same side. I won't argue the retroactivity issue in light of the Sylvain case, which apparently is going to do something that might affect that. So what I want to address is Article 26, if the court wants to hear about Article 26, as it may interplay with the remedy that's available. I'm sure you've read that when the legislature in 1982 enacted the current statute, 265-2, there's a specific severability provision in the statute. And the severability language, which I provided, there were a couple of typos in the appendix, but I provided a copy to the court yesterday, specifically references severability as to persons, as applied to persons. So if this ruling in Miller is retroactive, then what you need to look at is whether or not the fourth sentence is unconstitutional as applied to juveniles. And one of the first things defense counsel said was, it is. The fourth sentence is unconstitutional as applied to juveniles. Well, if it's severable, as the legislature specifically said it was to be, then you are left with the sentence, the second sentence, I believe, which says these sentences life in prison. And then if the exception to parole eligibility is out there, if the exception to parole eligibility is out under Chapter 4, Section 6, Clause 11, the general severability language, if you strike it out of the parole statute, which has the same mirror exception, then Mr. Diatchenko and others similarly situated are eligible for parole at 15 years of their sentence, after 15 years. And that's an entirely reasonable construction of the statute, comports with the legislative intent, comports with the severability language, and avoids any constitutional issue.
So you're saying that the consequence of the Miller decision would actually go beyond Miller, in that a judge would not have the opportunity, after individualized hearing, to sentence to life without parole?
Well, I think that because of our specific statutory scheme at this moment in time, if it applies retroactively, you need to look at the state of the law at the time he's sentenced and parole eligibility at that time and decide whether or not the sentence of life itself is still a lawful sentence. And I would say that calling our sentence life without parole is a colloquialism which is not really suited to our statutory scheme. The sentence is clear. It is life. The question of parole eligibility is separately determined by the legislature within that statute and the parole statute. So we could have a law enacted which would allow judges to sentence to life without parole. Or the court could take the view, contrary to this particular construction, that under the statute where it says life, the judge can impose life, and yet consistent with Miller, the judge can then, under his inherent authority, conduct a sentencing hearing and determine whether or not the exception applies to each individual who is being sentenced. So the exception can still be applied going forward on an as-applied basis individually under the inherent sentencing authority of the court. That's a reasonable construction going forward.
But you're limiting the options to those two. You're not, and I'll ask you the question, Justice Kagan, although discussing the particular statute that imposes parole eligibility with no parole opportunity, really talks about youth and mitigating circumstances that mitigate against that, and in the end says that the judge should be able to also consider a term of years.
Well, her policy statement is not the state of the constitutional law, even under the Eighth Amendment. All she says is, the holding of the case is you cannot have a mandatory imposition by the sentencer without considering the mitigating factors. The holding is not that you must have the option of a term of years available. That is not the holding of the case. And I don't think that under Article 26 or the Eighth Amendment you need to, you're dictated to say, oh, there must be a term of years option available. That just does not comport with Miller. The reason, though, the reason why you can't retroactively, I think, have a sentencing hearing and decide whether or not to apply mandatory life without parole, if Miller applies retroactively, is because we cannot have a hearing as if it's 1982, as if Mr. Diatchenko is still 17 years old, or any of the other 54, 55 people in that class.
Can't you see, though, what, as opposed to predictive, can't you see what, have a hearing which shows what has happened?
That hearing is a parole hearing.
No,
for the parole
no,
board
no.
to
I mean,
conduct.
if you can't, if Miller's retroactive and you can't do it as of the time the person was 17 years old, can't you, which is a predictive kind of hearing, you look at factors, the Miller factors, and you're sort of looking at, you can certainly take into consideration some of the Miller factors, the historical factors. But to the extent that the Miller factors are predictive, you don't need to worry about predictive because you've got actuality.
So it's a class of people that are
Right, they've
in
had-
this
oh, I
in this
understand. They've developed
circumstance
in a
because of
certain way,
right.
And here they are.
Yeah.
I mean, that's not really a Miller hearing. That's really a parole hearing is our position. And that's certainly appropriate for the parole board to look at that and all of the other appropriate factors.
Why would it be inappropriate in this because of Miller, if it is retroactive, because Miller was decided in 2012, and you have this class or group of people who are affected in that way? It's a defined, limited, self-limited class of people to whom it isn't a parole hearing, it would be a judge hearing.
Well, in the retroactivity cases, they do point to two principles that dictate against retroactivity, which are finality, which you would be destroying the finality here, and the other principle of the burden on the administration of justice of applying it retroactively. To try to put the burden on the district attorney to conduct a sentencing hearing and bring in psychologists and friends and neighbors and family members and the victim's family. Think about bringing in the victims and the victims' families of all these cases to the extent that's relevant to sentencing. It's really an inappropriate burden on the judicial system, I think. And in the principle of finality, these cases are fully and finally adjudicated. He made all of the exact same arguments in 1982. The only thing that's changed is the U.S. Supreme Court Miller case.
Well,
So I think that
and some scientific understanding of the adolescent brain.
Well, except that in Roper from 2005, what the U.S. Supreme Court said was, as any parent knows, and as the scientific and sociological studies respondent and his amici cite tend to confirm, A lack of maturity and undeveloped sense of responsibility are found in youth more often than adults. Since 1906, we've treated youths differently. We've treated juveniles differently. We've had a juvenile court system. Why? Because it's what any parent knows. Children are different. Juveniles are different. This line of cases is nothing, there's nothing new here. It's like, oh, now we have some scientific evidence that shows, I have an EEG that shows that the frontal lobe is not fully developed or fully connected. But we've always had that. We've always known that. Everybody who's been around kids or has kids or remembers growing up and being a juvenile certainly knows that juveniles are different. Now, I want to touch on, in terms of Article 26 and whether life is unconstitutional and you therefore have to have a mandatory term of years. Part of the evolving evolution of the juvenile system in Massachusetts, let's look at that picture. We've always, as far as I know, and I'm sure Chief Justice Ireland knows far better than I, the details of this, but juveniles have always been subject to adult trial and adult sentence if they were 14 years old. There was always a transfer system in place. So for as long, at least through the 40s and 50s, and every statute, every change in the law since then, juveniles have always been subject to life without parole in Massachusetts, the way our statute supposedly works, or at least life. Second-degree murder is life. First-degree murder is life. That's the sentence.
I'm sorry, is the argument here that life with parole is unconstitutional? Or life without parole is unconstitutional?
I believe defendant is arguing both of those. That's what I think he's trying to
And just to be
articulate.
clear, I just want to make sure what your position is. As I hear what you're saying, you are saying for all those who were sentenced before Miller, who received life without parole, they now would receive life, which would mean the possibility of parole. But for all those sentenced prospectively, there would be a Miller hearing. Is that what you're proposing?
Yes, and as Justice Lenk points out, you can reject my position and order Miller hearings retroactively. I'm proposing it partly as a matter of finality and practicality.
Okay, but I mean, practicality, the DA could always say, even if there is a Miller hearing, we don't choose to, we agree with the defendant that there should be life with parole, and that would obviate the need for a Miller hearing.
Correct, but there are some cases in which that will not happen. I can assure you of that fact.
Okay,
There are
so-
some cases where the DAs will say, we're going to try to have that hearing, and we're going to do our best, whether the case is 10 years old, 15 years old, 20 years old, or 30 years old.
But you say that constitutionally and as a matter of statute, that the DAs would not be entitled to that hearing except prospectively.
Well, no, I wouldn't say that categorically. It depends on the construction, the remedy construction you adopt. If you adopt Miller and say it is retroactive, I don't think that the sentencing hearing really is a great alternative. I think you can do it. It may not be the most reasonable reading of the statute, but certainly it's a plausible reading of the statute.
But for the problem that you're talking about, we could say that that retroactively, in order to get a sentence of life without parole, there must be a hearing in all cases, and then the DA can decide whether or not he or she wants to proceed with that hearing. If they don't proceed with the hearing, then the sentence is murder too.
Well, the sentence is life.
Is life,
And
yeah.
the exception to parole eligibility doesn't apply.
Yeah.
Yes, you could do that. I just want to, though, just to finish up on Article 26, the evolving standards in Massachusetts, first of all, juveniles were always subject to adult sentences in trials, always, as far as I know. And they were subject after a transfer hearing. In 1991, and so you had a divergence, you either had a transfer hearing, went to adult court and got the adult sentence, or you stayed juvenile and your maximum exposure was DYS to 21. In 1991, the legislature said, that's not appropriate. What we're going to do is have a 15-year minimum, 20-year maximum. So part of it could be in juvenile facility, even if you didn't get transferred, but then you have a prison sentence after that. So our evolution in terms of our juvenile law is toward greater sentencing. So when you're looking at Article 26 and the evolving standards, you have to look at that and say, well, we evolved in a different direction. We evolved in a more punitive direction, if you want to phrase it that way. And then in 1996, we evolved again, where we said there are large categories of juveniles that are subject to prison sentences when indicted as youthful offenders, including armed robbery, life sentences for lots of violent crimes. And Mr. Diatchenko was convicted of armed robbery, so at a minimum, he gets a life sentence exposure for that here, felony murder. And the other change was automatic adult indictment, 14 to 17. So under Article 26, our whole movement has been, I think, toward greater sentencing and away from this, treating juveniles simply as children in need of aid and guidance. Unless the court has other questions, I'll rest on the brief.
Thank you, Counsel.
May it please the Court, Assistant Attorney General Amy Karangekis, on behalf of the Chair of the Parole Board and the Commissioner of the Department of Correction. For the reasons detailed in their brief, the Board and DOC do not take a position on the core issues before this Court, on whether Miller is retroactive, and if so, the appropriate remedy. Both entities, however, dispute petitioner's assertion that if he is declared parole eligible, the current parole system in Massachusetts could not provide prisoners such as petitioner with a meaningful opportunity for release that Miller requires. Apart from the fact that this argument is based on unadjudicated factual allegations that are not properly before the court, the apparent legal argument is both misplaced and spacious.
Do the guidelines that the parole board follows can take into account Miller-type factors?
Yes, Your Honor, and we've detailed that in our brief. In determining parole suitability, the parole board, by statute, is required to perform a risks and needs assessment.
Where youth is taken into consideration?
Excuse
Youth
me?
at the time of the crime is taken into consideration?
If you look at, and we've outlined in our brief, and if you want to look at Record Appendix 151, there are guidelines for first-degree offenders. And presently, the parole board considers juveniles for life in second-degree murder cases. And some of the factors that they consider are inmate rehabilitation, inmates' recognition and understanding of the issues that caused him to commit the crime, demonstration of rehabilitative character and reform behavior.
What about the circumstances at the time?
Yes, Your Honor, they also look at the facts of the crime with a focus on the inmate's criminal conduct, any aggravating circumstances.
What about the youth of the individual at the time of the crime?
While they don't use the word youth, if you look at another factor they consider, an inmate whose criminal...
Could you say the page again? Where you
Yes, Your Honor, Record 151, and that is the guidelines for life sentence decisions. So the way that the parole system is set up in Massachusetts, it's not a hollow review, and it affords all offenders, including juveniles, a meaningful review, determination, and opportunity to obtain release if parole eligible.
Let me clarify your position. I had thought your position was that on this record, we cannot make an evaluation of whether there's a meaningful opportunity for release, and we should not reach it.
That's correct, Your Honor. That is correct. This is just in response to the argument that he tries to put as a legal argument. The current parole system, if I become parole eligible, the parole board will not be able to determine parole suitability.
But do you agree that if life sentences with the possibility of parole were to still be available, and if in the course of time plaintiffs could demonstrate that there is no meaningful opportunity for release, that they could, under Miller, challenge the parole board's conduct with that constitutional claim?
Yes, Your Honor. On an appropriate record, yes. As you stated, our first and foremost position is that on this record, the court cannot make a decision on that.
Counsel, your time is up.
Thank you.
Thank you, Your Honor.